In the Court of Appeals of the State of Oregon, Kara Johnson, DBA Duck Stop Market petitioner, Oregon Bureau of Labor and Industries respondent. Argued and submitted June 21, 2016. So this was last year. So let's get to the meat of it, shall we? In the final order challenged in this judicial review proceeding, the Oregon Bureau of Labor and Industries, BOLI, that's who they are, determined that respondent Johnson, owner and operator of Duck Stop Market, violated, and there's the codes, when she refused to allow complainant, an individual with a disability, to enter DSM with a service dog. In seeking judicial review, Johnson makes 3 narrow arguments, each of which we reject for the reasons set out below. Accordingly, we affirm. I love this legal stuff. I don't know about you guys. On April 17, 2013, complainant visited DSM, accompanied by her husband and 2 dogs, Contessa and Panda. Complainant is visually impaired, hard of hearing, and has been diagnosed with PTSD, agoraphobia, and schizophrenia. Along with a friend, Merlin, complainant operates Sunstone Service Dogs, a nonprofit organization that trains service dogs. In April 2013, Contessa was still considered in training with Sunstone Service Dogs. However, by that time, she had been trained to assist complainant by performing several tasks, including covering and chest compression during a PTSD attack, alerting complainant to take her medication, opening and closing doors, providing tactile stimulation, helping complainant walk through crosswalks, alerting complainant to traffic, leading complainant to vehicles that she was to travel in, and helping complainant avoid running into objects. So she was already tasking and behaving in public, like I thought. By the same date, Panda was trained to assist complainant by performing tasks, including covering and chest compression during a PTSD attack, waking complainant from nightmares and calming her, helping complainant breathe again after complainant stops breathing at night, and ensuring that complainant does not run into street curbs or objects. When the complainant and her husband visited DSM on April 17, both animals were leashed, and Contessa wore a service dog in training vest, along with a soft muzzle and training harness. Why was she muzzled? Do they mean a head halter? They must mean a head halter. She wouldn't muzzle a dog. Shortly after the complainant, her husband, Contessa and Panda, entered DSM. Respondent said they could not bring dogs into the store and that they needed to leave. Complainant informed respondent that Panda and Contessa were service dogs and referenced a sign in the DSM's front window allowing service dogs. Respondent stood by her initial statement, suggesting that complainant use the DSM's drive-up window or let DSM employees hold the dogs outside while complainant shopped. Eventually, complainant stayed outside of DSM with Contessa and Panda while her husband went into the store. You know, with the California Department of Fair Employment and Housing, they're just awful. They would tell you that you weren't denied shopping because your husband went in. So you weren't denied anything and they wouldn't help you. Just fun fact there. After that visit, respondent briefed her employees on the incident and told them that she did not want the dogs in DSM. Meanwhile, complainant completed a BOLI Civil Rights Division Public Accommodation Discrimination Questionnaire online and asked Elizabeth Fuel, a caregiver, to help her organize paperwork about service dogs and to accompany her to DSM the next day as an observer. On April 18, complainant and Fuel visited DSM, bringing Contessa, who wore her service dog in training vest. Respondent was not present, but a store clerk met complainant and Contessa at the door, telling complainant, "You're not welcome here. Your dog needs to leave." Complainant notified the clerk that Contessa was a service dog, and Fuel announced that she was recording the conversation. The clerk told the two that she did not care and threatened to call the police if they did not go outside. Fuel then called the sheriff's department, and while the complainant and Contessa waited in Fuel's car for deputies to arrive, someone from DSM came out and told them that no matter what happened, they were 86th off the property. When deputies arrived, they took handouts that complainant and Fuel had brought along and gave them to the clerk before asking complainant and Fuel to leave, suggesting that complainant come back the next day to meet with respondent. Complainant was upset by that incident and decided to complete a new online BOLI Civil Rights Division Public Accommodation Discrimination Questionnaire, addressing that experience, and to go back to the store the next day to meet with respondent. On April 19th, complainant returned to DSM with Contessa and Merlin. Respondent and the store clerk met them in front of DSM, and the four had a conversation in which respondent agreed to read material about the Americans with Disabilities Act that complainant provided her, but also told complainant that dogs were not allowed in DSM and that complainant was not allowed back to DSM until respondent decided what she would do about complainant's dogs. A few days later, respondent called complainant to notify her that respondent had read the materials and would allow complainant to shop at DSM so long as she brought only one dog. Complainant did not return to DSM after that conversation. Complainant experienced trauma from her interactions with respondent and DSM and became more reticent about leaving her home. Yep, that's what happens. You get traumatized. Following those events, respondent and her employees committed multiple acts that did not take place at DSM and caused distress to complainant, which BOLI determined contributed to its damages award, including mailing a letter to Merlin at Sunstone Service Dogs, which complainant perceived as a threat, following complainant as she took a bus, following and photographing complainant and her young granddaughter on a walk, and photographing complainant's apartment and complainant's neighbor's car. Within a few weeks of the incidents at DSM, complainant filed a complaint with BOLI, asserting that respondent had discriminated against her because of her disability. BOLI subsequently issued formal charges alleging, as pertinent here, that respondent had violated, and there's the code, which prohibits any place of public accommodation from making any distinction, discrimination, or restriction because a customer or patron is an individual with a disability. Specifically, BOLI asserted that respondent had violated that statute on each of 3 days by refusing to allow complainant to shop at or enter DSM with dogs that were trained to assist with complainant's disabilities, including visual impairment. BOLI requested that complainant be awarded at least $30,000 in damages for physical, mental, and emotional distress. After a contested case hearing, BOLI issued a final order that includes 2 legal conclusions that respondent challenges on judicial review. That respondent violated the code on April 17th and 18th by refusing to allow complainant to enter DSM to purchase groceries while accompanied by her service animal, and 2, that respondent violated, there's the code, on April 19, 2013 by telling complainant that her dogs were not allowed in DSM and that complainant was not allowed on DSM's property until respondent determined what to do with complainant's service dogs. BOLI ordered respondent to pay $60,000 in damages for the emotional, mental, and physical suffering that complainant experienced as a result of respondent's unlawful practices. In addition to challenging Boley's determination that she violated, there's the code, respondent challenges that damages award. Before addressing respondents' challenges to Boley's final order, we explain the reasoning that Boley employed in determining that the respondent violated the code when she refused to allow complainant into DSM with her service dogs. Boley's rationale is based largely on the code, amended by Oregon laws 2013, which referenced the ADA and which this court has called a lockstep statute. Evans versus Multnomah County Sheriff's Office. The lockstep statute requires that certain Oregon statutes that prohibit discrimination against people with disabilities be construed consistently with similar ADA provisions to the extent possible. It provided, in pertinent part, let me scroll, shall be construed to the extent possible in a manner that is consistent with any similar provisions of the Federal Americans with Disabilities Act of 1990. As amended by the Federal ADA Amendments Act of 2008 and as otherwise amended. Noting that the version of ORS Chapter 659A in effect in April 2013 did not include provisions related to allowing service dogs in places of public accommodation. Boley, in reliance on the lockstep statute, turned for guidance to Title III of the ADA. And scrolly. The referenced federal regulations required places of public accommodation to permit individuals with disabilities, tongue's getting tired, the use of a service animal, except if the animal is out of control and the animal's handler does not take effective action to control it, or the animal is not housebroken. A related regulation on which Boley also relied defines service animals to mean any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. So they brought up that she was mentally ill and that didn't count. Wrong. Based on that federal law and the code, Boley concluded that Oregon law in April 2013 required places of public accommodation to allow individuals with disabilities to be accompanied by their service animal, unless the animal was out of control or not housebroken. Boley further determined that both Contessa and Panda were service animals, and that the respondent therefore violated the code when she refused to allow complainant to enter DSM while accompanied by one or both of the dogs. As noted, Boley's final order reflects those determinations and imposes a $60,000 damages award, and respondent seeks judicial review. We discuss each of the respondents' challenges to Boley's final order below. Preliminarily, however, we explain what respondent does not challenge on judicial review to clarify the narrow arguments that she makes to this court. First, respondent does not dispute either that DSM was a place of public accommodation as defined in the code, or that complainant was an individual with a disability for the purposes of the Oregon statutes prohibiting disability-based discrimination. Second, the respondent does not challenge Boley's reliance on the ADA and associated federal regulations as the basis for concluding that in April 2013, Oregon law required places of public accommodation to allow individuals with disabilities to be accompanied by their service animals. Third, except as discussed below, respondent does not challenge Bowley's reliance on the definition of service animal that is supplied by 28 CFR section 36104. I think that's Title 2 of the ADA. Finally, respondent does not contend that the factual findings in the order are not supported by substantial evidence, nor does she contend that the order is not supported by substantial reason. Rather, respondent raises only narrow challenges to certain aspects of Bowley's legal reasoning. Accordingly, we review those parts of the final order for legal error. And it says, see another code. If the court finds that the agency has erroneously interpreted a provision of law and that a correct interpretation compels a particular action, the court shall set aside or modify the order or remand the case to the agency for further action under a correct interpretation of the provisions of law. So they can, claim they interpreted the law wrong and it has to go back to be rectified. In her first assignment of error, respondent contends that Bowley erred in concluding that Panda was a service animal on April 17, 2013. The ADA requires that a service animal be under the control of its handler. Respondent argues that the term handler, as used in the regulation, refers only to the individual with a disability to whom the service animal is assigned. Here complainant, and that because Panda, here complainant, and that because Panda was under the control of complainant's husband during their visit to DSM, respondent has the right to exclude Panda. No. In the discussion of the ADA, they specifically, the service dog stuff, I'd have to look it up, but they specifically discussed a temporary handler bringing a dog to the actual handler or taking the dog away. Say somebody was in the hospital and the service dog wasn't going to stay with the person in the hospital, or if somebody was in the hospital and they had their service dog and somebody came to take the dog outside, run them outside to potty and stuff for them, that a temporary handler handling the dog in place of the actual, person the dog's for is acceptable. Just FYI. We disagree. The respondent offers no reason that the term handler in Title II, I believe it is, should refer only to the individual with a disability. Neither Title II nor the other section, because I don't want to even have to go through saying all this, which defines service animals, limits the term handler to the individual with a disability. To the contrary, the United States Department of Justice, which implements the ADA, issued a final rule correction in 2011 clarifying the definition of service animal in the ADA, which had previously included the following text: the work or tasks performed by a service animal must be directly related to the handler's disability. Non-discrimination on the basis of disability by public accommodations and in commercial facilities, final rule, blah, 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 blah. The rule was corrected by replacing the word handlers with the word individuals. Non-discrimination on basis of disability by public accommodations and in commercial facilities. Corrections. That change to the text of the rule was accompanied by the following explanation. Because a service animal is not always controlled by the individual with the disability, the service animal's handler is not necessarily the individual with the disability. That rule correction defeats the respondent's argument that Panda was not a service animal because complainant's husband was the animal's handler during the April 17, 2013 visit to DSM. Respondent's second assignment of error challenges Bowley's determination that Contessa was a service animal at all. Respondent primarily contends that Contessa did not meet the ADA definition of service animal because she was still in training and therefore was not a dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. Emphasis added. Because Contessa had not completed her training, respondent concludes she was not a service animal that respondent was required to allow into DSM. In response, Bowley points to its unchallenged factual finding that although Contessa was still in training during April 2013, she was, I'm inserting already, trained at the time to perform specific tasks to mitigate complaint